like to thank Claire Ferris, and I think for those of you that were here for the first forum, you can see why we asked him to be our moderator. Let's give Claire a big hand. And without further ado, I'll turn the microphone over to him for our next forum. Thank you, gentlemen, for being with us.
I do want to thank you for being here with us today. And just a reminder, you're going to have an opportunity to have a 3-minute opening statement. Give that opportunity to you, then we will be asking you the questions. You have 2 minutes to reply. Your timers are back there, and they'll give you the yellow when you've got 30 seconds and the red when you need to pass off the mic. At the end of this, we will look for some questions if there is time that the crowd can ask you. We'd ask you to stay and answer questions in the lobby for a few minutes if you have a few moments. You will have a closing statement of 2 minutes at the conclusion. So we'll begin with our first question here, and we'll start with a statement from me. Seniors with dementia or Alzheimer's on medications or even experiencing a urinary tract infection. Oh, that's right. Let's have your statements. I guess I'm interested in vegetarian quiche.
I guess no one's heard enough statements from politicians.
That's right. So, Victor, would you like to introduce yourself and start with your yes, please? And thanks for your reminder.
Is this good? Can you hear me?
Yeah.
Great. My name is Victor Harris. I'm an attorney, graduate of Stanford Law School. Went from Stanford Law School to the Los Angeles District Attorney's Office, where I practiced for 14, 15 years. I tried murder cases. I tried robberies, home invasions, dual jury trials. Went from there to a special unit where I prosecuted white-collar crimes involving thefts of over $1 million that were too complex for central trials. At the prosecutor's office there, I learned the values of being a prosecutor, which included you were there to do justice and not just get convictions. Doing justice meant finding the right result, no matter the cost to you professionally. Because getting a conviction is how people were recognized in the office. But I always sought to do justice as was taught to me. One of my proudest moments as a prosecutor was walking in and dismissing a case, a murder case, against 2 young defendants who had been accused of killing an ice cream vendor. After doing the investigation and further investigation and talking to all the witnesses, going out to the scene and examining what had happened, we realized we had the wrong people. I convinced my superiors that we had the wrong people, and those men were set free to go on to live productive lives. Now, it's possible to get a conviction on flimsy evidence, and that's one of the dangers and temptations of being a prosecutor. I resist that in every aspect of my life, as an attorney in civil and in criminal practice. I'm running for Thurston County prosecutor because I want to bring a sense of respect for the oath of office back to Thurston County. I want to bring reform, real reform that works, and not just the names of programs that do not, in actuality, help very many people. I want to live within the means of the county by not filling the jail so full that we have to pay other counties to house our people, and so full that we have to expand our jail even now when our so-called reforms are allegedly in place according to Mr. Blake and the incumbent. The reforms aren't working. In 2010, Thurston County sent, on a per capita basis, 178% more people to prison than King County. Now it's 2018, and that rate, at least as of last year, according to the Department of Corrections, is over 200% the rate of King County. Those are not real reforms, and that's why I'm here, and that's why I'm running.
attorney, and I'm running for re-election and asking for your support. I've been working in this system for 30 years. I bring 30 years of experience working in the Thurston County criminal justice system. First as a legal intern, starting in 1988 in the prosecutor's office, then as a deputy prosecutor for 20 years. As a deputy prosecutor, the focus of my practice predominantly was cases involving what we call special victims. In other words, cases involving sexual assault, felony domestic violence, and child abuse. When I was a deputy prosecutor, I co-led the effort to create now an organization called Monarch Children's Justice and Advocacy Center, a system that provides holistic support for child victims of crime. And as prosecuting attorney in the last 8 years, I've been an advocate and a voice for criminal justice reform that we'll talk, I'm sure, more about as we go through this. But I want to tell you that I've had 4 values in place during that entire time. One is, above all, protect the community, keep the community safe. That is really a core function of the prosecuting attorney's office with respect to its criminal division. Support victims. One of the crucial roles of the prosecutor in the system is to be an advocate for victims' rights and to be that voice for victims and to make sure that their voice is heard. Make sure they have an opportunity to be heard. Third, be smart on crime, which means look at each case individually and look at, instead of just not only just what the person did, but why they did it. And what can we do to address that issue? It has forced our prosecutors to change our definition of a win, to not just look at a win as a conviction and a long prison sentence, but to look at a win as a long-term improvement of public safety. And the fourth thing is to be an advocate for prevention. I've been very involved in this community as a long-time volunteer with organizations that support families, children, and seniors. And I will continue to be that advocate. I fully believe, frankly, that our best, long-term public safety strategy is to prevent crime. And to do that, we need to be not only looking at the short term, but to also be looking down the road, and in particular, looking a generation ahead. Those are the 4 things that guide my philosophy as a prosecuting attorney. Those are the values that I give to my deputy prosecutors. I've created a great team that have embraced that idea, those ideals, and I am very much looking forward to continuing the work that we've started over the last 7 years. Thank you.
Thank you, gentlemen. John, if you want to just keep the mic while we get the first opportunity to answer the question. Seniors with dementia or Alzheimer's on medication or even experiencing urinary tract infections can often experience drastic behavioral and personality changes, sometimes even becoming violent. What discretion do prosecutors have in charging when they see such behavior being exhibited? And what responsibility do prosecutors have in connecting those charged with services of support?
Thank you for the question. So I'll tell you about 2.5 years ago, we lost my mother-in-law to Alzheimer's disease. It's an issue that's incredibly important to me and one that I understand very, very well, watching my wife and her family go through that experience. And we are aware of the behavior changes that can occur. When something like that happens and we have a severe behavior change, that's really where prosecutorial discretion becomes very important. Because again, we need to look at not just what the person did, but why they did it, what's going on behind the scene. When something happens like that, we really need to just slow down. Oftentimes the criminal justice system can be an intervention to just stop things and to be able to step back and slow down and take a look at what's going on and then work towards some kind of a resolution that ends up with, again, public safety, but also a good outcome for that person who's accused, but also an outcome for the family and the victims that might have been affected by that. It's one of the reasons why I am a believer in prosecutorial discretion and being able to look beyond just what the person did, but look at why they did it and really try to address that issue.
It's one thing to believe in prosecutorial discretion. It's another thing to set actual policies and rules and guidelines for your prosecutors. And that does not exist in the current prosecutor's office. Last summer, on June 1st, 2017, the National Council of Superior Courts issued a report discussing how exceptional Thurston County Prosecutor's Office is in that it has no operating manual. It has no policy guidelines. It has nothing to set the standards by which the prosecutor should realize what factors might apply to any particular case. If someone had Alzheimer's and acted out in a particular case, there's nothing requiring any prosecutor in Thurston County to apply any particular kind of discretion, seek any type of medical opinion, or provide any kind of exceptional procedure other than what that prosecutor feels is necessary. So that's not prosecutorial discretion, that's chaos. And in a county that's growing, and projected to grow by 100,000 individuals in the next few years, and has grown substantially since 1970 as well, we need procedures and policies so people in different cases are treated similarly, not depending on which prosecutor gets the case or happens to know more about Alzheimer's or some other medical condition that they're familiar with through their family life. We can't depend on that. Thurston County is too big for that, and we have to look at the recommendations in that report and see where the prosecutor's office has failed us severely. It shouldn't depend on who you get, whether or not you're charged with bail jumping, or you get on and go to prison, or you go on probation and go about your life.
Victor, keep the mic with you. Okay. So our next question refers to this. The county currently has a law enforcement assisted diversion program that keeps first-time or low-level drug offenders out of the criminal justice system. Do you feel the program is successful, and why or why not?
Back in around 2015, the incumbent started talking about the innovative justice system or platform for Thurston County. And one big aspect of it that he's discussed is the Law Enforcement Assisted Diversion or LEAD program. Since 2015, he's gone to many groups, including Tumwater City Council, and discussed what a great innovation this was. And indeed, as it was set forth in Seattle, where it was created, it was a great innovation because it reduced recidivism by almost 60% and in one category of crimes and 40% in another. And it led to a decline in crimes in the jurisdictions where it was operating. However, when it was brought to Thurston County, it was modified so much, it was so unrecognizable from the system in Seattle, that the Seattle LEAD Council did not certify it as a LEAD program. They allowed Thurston County to use the name, but it is not a LEAD program in actuality. So in late April, when I brought to the attention of the Democratic Committee that, in fact, only one person had ever gone through the LEAD program, they were in disbelief. I was in disbelief when I first heard it from public counsel, that it's a program in name that has helped apparently one person. Now we can name program after program after program, but unless we actually know what the numbers are, we're just kidding ourselves that reform is real here in Thurston County. And now I have heard again and again that we're a leader in reform, but the numbers just don't back that up. One person does not make a program. We need real LEAD program here in Thurston County, more pre-booking diversion programs, and more efficient prosecutorial practices. Thank you.
So my opponent mentioned the innovative justice which came out of a collaboration that formed about 4 years ago between the County Commissioner's Office, Prosecutor's Office, Public Defender's Office, and the Thurston County Sheriff's Office. And we laid out a number of reform strategies, one of which was looking at the LEAD program in Seattle. LEAD was developed in Seattle in the Belltown area to specifically address open-air drug dealing going on in that Belltown area. It is a law enforcement diversion program, so it contemplates that law enforcement officers will make that diversion decision directly from the street and to have somebody go into the program. It had, as my opponent said, it was a promising practice. It had significantly good data behind it. We decided to replicate it. We did replicate it. I would seriously disagree with my opponent's characterization that this was modified. All of the fundamental elements of LEAD were put in place. LEAD doesn't certify programs. They allow you to use their trademark. They allowed us to use their trademark. We created the protocol. We created a partnership with the VHO to do the services, the case management services, and created the protocol for law enforcement to do that referral to an organization called the Mobile Outreach Team. We didn't get the referrals. And my conclusion from that is that law enforcement at this point in our county is not comfortable making diversion decisions. And so we've taken all of the elements of that LEAD program and now incorporated it into our new diversion unit called First Look, which you heard a little bit about in the previous debate. First Look is a unit now in my office that has 3 FTEs whose sole purpose is to proactively seek out and look for cases that can be diverted. We've taken all the elements of the LEAD program now, incorporated it into First Look, and we've already, within 2 weeks, had our first LEAD-like diversion. We don't call it LEAD anymore, but it's LEAD-like. Thank you.
John, we'll keep you going here with the next question. The cash bail system allows low-level, non-violent offenders to be able to post bail and continue with their lives without awaiting trial, while awaiting trial. For low-income individuals or those living in poverty, posting bail can be a struggle or impossible. Are there alternatives to a cash bail system that would allow low-income individuals or those who are unable to post bail stay in their homes and keep working within the community?
Yes. So bail reform is a significant issue and significant conversation going on in this state right now. In fact, there's a statewide bail reform task force that's discussing some of the very things that we've already done here in Thurston County. In Innovative Justice, one of the other strategies that was produced there was to create a more robust pretrial services unit. You heard a little bit about that in the previous debate. We have a very small, very specific pretrial services program that fell underneath the Superior Court for many years. As part of Innovative Justice, we took that program out from underneath the Superior Court and created a separate county department called the Department of Pretrial Services that is governed by a board that has all of the criminal justice stakeholders as part of that board, and added significant resources to that pretrial services program. That's the key to allowing people to be released without bail, because we have a unit that can provide them support, give them reminders to come back to court, and supervise them on the conditions that the court might set for them. Eventually, my preference would be, my advocacy would be to try to move away from a system that has money bail at all, and have judges making decisions solely based on the risk that a person is at for the community to reoffend, and making those decisions based solely on the risk and the circumstances of the case. And either that person is detained because they are deemed to be too high a risk to be in the community, or they are released because they are deemed safe to be released to the community. I will tell you, last night I was in a meeting and our jail chief reported some pretty significant reductions that are just now, I think, coming into place with all of the new things we've done with Innovative Justice. Jail population overall is down. Pretrial population overall is down, as is the number of beds that we use on contract. Thank you.
Bail reform is crucial. We're going to have to depend on the legislature for a lot of that, but I will be an advocate for that. One of the crucial things that we need to realize is the Thurston County prosecutor testifies a lot before the legislature because he happens to be in the state capitol. My opponent has testified many times against reform bills. Most recently, he testified against juvenile justice reform, in which legal financial obligations which keep a juvenile's record open indefinitely into adulthood should be repealed so that they can go on to live productive lives. Mr. Thunheim testified against that. Every time there's been a significant change proposed in the law to reform that, Mr. Thunheim has testified against that. For the De-Escalate Washington proposal, in which the use of force by police officers was worked on in an initiative form, his office was approached to try and help with drafting. They didn't help, so De-Escalate Washington went on in an initiative form. Time and time again, there's been opportunities to step up to the plate for real legislative reform, and the ball's been dropped or openly opposed by your own prosecutor's office. I'm looking for real reform in the bail system and also in the jail. Our jail is at 105% capacity year after year after year, and that can't go on. Most of the people in our jail are in jail awaiting trial. They haven't been convicted of any crime. The majority of people in our jail have not committed any crime. I want to stop that.
All right, we'll keep that mic in hand. We're going on to our last question here, and it's a reference to what you just talked about. The Olympian frequently reports that Thurston County Jail is often overcrowded and looking for neighboring counties to help out. What are the main factors that lead to overcrowding, and what are some of your proposed solutions?
Thank you, that's a great question. Since most of the people in jail are awaiting trial, the number one thing to lessen the congestion in there is to actually get cases to trial in a timely fashion. There is a culture of continuance in Thurston County and the criminal justice system. Part of that is because evidence is not turned over in a timely fashion. When evidence is not timely turned over, when it's turned over on the eve of trial, the defense has to ask for a continuance in order to investigate that. And the prosecution points the finger at the defense and says, well, it's their fault because they asked for the continuance. No. If you're managing your cases effectively, if you're managing criminal investigations after filing effectively, you've got the evidence ready, you're ready to go to trial. And I will change that. I will make us ready to go to trial so cases go to court expeditiously or tried. My opponent has been the chief of the criminal division since 2003. So since 2003, he's controlled the culture of continuances in Thurston County. He became the prosecutor in 2010 and had full authority to make any changes he wanted to, but nothing has changed. People can't get their civil cases to trial because the criminal cases are crowding them out. That's the number one thing I would do. I would also seek to manage the jail based on our resources. If we have too many people in the jail, then we need to cut down on the sentences we ask for, or the filing, or the number of cases filed. And some of those more marginal cases need not to be deferred for filing. I want to live within our means. Right now, if we could cut the jail population by just 10%, that would be almost $2 million in savings per year. And yet right now, we're going to borrow $11 million, maybe $13 million to build yet another addition to our already huge jail.
seriously mischaracterized the testimony that I've given before the legislature, and I don't think I've ever testified in opposition to a criminal justice reform aspect. With regards to I-940, we may be able to talk about that later. The Prosecuting Attorneys Association, of which I am the current president, actually helped barter the agreement between community advocates and law enforcement labor to pass a bill called House Bill 3003, which is a very good compromise in my view on the use of deadly force, and one that was supported widely in the legislature. And also forgot to let you know that I testified in favor of a bill called Justice Reinvestment, which would have changed the way we do our sentencing in Washington to allow us to invest savings from incarceration into other programming. As for the contract beds, the issue is, in fact, how slow the process has been moving in Superior Court. There has been a culture of continuances in which everybody's had a hand in that. The court, the public defenders, the private bar counsel, the prosecutor's office, and that has been rectified basically with a new system implemented that embraces something called differential case management, which I've advocated for actually for many years. Differential case management means that we set realistic trial dates, we work our cases towards that date, and the case gets resolved or goes to trial prior to that or on that trial date. Between that, the pretrial services, the diversion programs we've talked about, that's where we're starting to see the results in the data that I talked about. Population going down, use of outside jail beds going down, pretrial population going down. Thank you.
Thank you. So right now, folks, we're going to switch this around a little bit and give you an opportunity to ask some questions. We have about 8 minutes or so. We'll start over here. We're going to give you fellows a chance to respond a minute apiece, okay?
I want to address something that came up. Something came up in the previous group, and is here now again, about the number of people that are in prison here, the percentage of our budget that's involved in it. And I'm not interested in sound bites about what you think or what you thought. What I'm interested in is the mechanism, the actual mechanism. If there's a system in place to divert people that don't belong in jail, that can be diverted effectively, what's the mechanism to discover that this person in this cell, this person in custody, this person that hasn't looked yet, has Alzheimer's, they're bipolar and manic, they're bipolar and suicidal. There's something there that says they're mentally ill. What's the mechanism to get from there to there that doesn't put them in jail cell?
There is no effective mechanism. You just heard my opponent say that the LEAD program, which was a pre-booking diversion program, is a failure here in Thurston County. The diversion programs he's discussing are all post-booking, post-arrest diversion programs which are far more expensive. Okay. You've already got a case filed, you've got lawyers on both sides, you're already in the system. This first look label that he's putting on what sounds like normal case management to me, I don't understand how that solves the problem. He's just describing in first look what every prosecutor should be doing in every case, examining whether or not it can be handled in some way short of sending someone to county jail for a year at $43,000 per year for the cost of the taxpayer, or to state prison at $47,000 per year on average to the taxpayer.
I want to just say a couple of things about the funding issue and then about the real question you asked about getting people out of the system. The criminal justice system, I should say law and justice system in Thurston County is about 75% of the general fund of expenses. That is not the county budget. There is a difference. Law and Justice incorporates not just criminal justice, civil justice, courts, and clerk, and all of that as well. So it's all lumped up into one big category. When you look at it in contrast to the overall county budget, it's about 25% of the county budget. The reason for that is that roads has a separate levy. Public health gets a substantial amount of money from the state and the federal government. But counties get absolutely no state or federal support for criminal justice, law enforcement, or public safety. And so it's all that cost is saddled on county government and city government, which is why counties all over the state have exactly the same issue that we're dealing with. I'll lead what has been a pre-booking system, and I haven't given up on lead. I will tell you that the diversion program I'm talking about is pre-charge. Pre-charge, meaning people don't get charged. They get out before they're charged.
Thank you, John.
Thank you.
On to the next question.
One in the back there. Question's kind of long, it's for Mr. Dunham. So the consultants from the National Center for State Courts in their 2017 report, Thurston County Court stated that the lack of supervision of deputy prosecutors and ineffective pretrial conferences contribute to poor quality decisions regarding which cases to take to trial. It also says that there are too many trials. In March 2015, I wrote an email to one of the deputy prosecutors. I'll tell you that is afterwards if you want to know. The person said, "Thank you for your inquiry regarding the standards for filing a disposition. There are no written standards regarding this issue."
Need to get to your question,
The
please.
question is this: how do you hold deputy prosecutors accountable when you have no case filing standards and no performance standards for employees?
Well, no case filing standards doesn't mean we don't have performance standards. And I think your request was probably in the form of a public records request looking for standards within our office. I will tell you that Washington state law has prosecutorial guidelines and standards for both charging and disposition. So our policy in our office is follow the state prosecutorial guidelines. Those guidelines, I think, give very appropriate guidance and discretion at the same time to prosecutors in both in how to charge and resolve their case. I found it very interesting that my opponent in the last question was talking about things that really involve prosecutorial discretion, the ability to really look at and analyze cases more than just what happened, but who they are. My office is divided into small trial teams. We have a culture and a management system that oversees every deputy prosecutor in every case, such that we have consistency, we have common staffing in the case, and the deputy prosecutors are fully aware of what the expectations are in the office. Thank you.
Victor?
Whatever the culture is, it's not working, and it's costing the county tens of thousands of dollars a year, if not hundreds of thousands of dollars a year, and it needs to be changed. The kind of standards he's talking about in the code and the rules, the RCWs, came about through sentencing reform a while back when King County had its manual. It's basically policies and procedures, which is still available online. And there was a push to implement that statewide. And some of the smaller counties didn't want to have a manual that they had to follow. So a compromise was reached in which a few key provisions were pulled out and put into the RCWs in the codes. Those are inadequate for Thurston County today, with 32 prosecutors, a population set to grow by 100,000 people, and a wishful culture that everybody's going to do the right thing because they're using their discretion properly. More guidance is needed.
Thank you. And we have time for one more question. That was right. There was one right over here.
And I don't need to ask.
You don't need to ask it. Any other question? No, a quick question.
Yes, I'd like to know your thoughts about and experience with restorative justice.
Thoughts and experience about restorative justice?
Restorative justice means different things to different people. It's one of those concepts that I'm wary of. I love the idea of it, but for some people, violation, and I don't think that works for many types of cases. But if it doesn't, some people means that the person who committed the offense is brought back into society by giving them the correct guidance and support needed to overcome whatever issues that person had moving forward. And in that sense, I'm totally in favor of restorative justice. Now, don't get me wrong, there are some people who are beyond help and who just need to go to prison for a long time. And I sent many people to prison, and there's still people in prison that I put there 15 years ago. So I don't mean to say that I think restorative justice would work in every circumstance. I agree with the concept for most cases.
Well, just so I can be clear, when your question of restorative justice, are you talking about the model of facilitated mediation in the criminal justice system?
Yes.
Yeah.
The victim actually hearing.
Yes, yes. I am incredibly interested in restorative justice, to be honest with you, and I have been for a while. And I've been looking for a way to try to kind of make this happen. We have restorative justice elements in the juvenile justice system in this county already. Community Youth Services, which does our diversion program, has from time to time used restorative justice models as part of that diversion program. It's interesting that you would ask me this because just about a month ago I met a young lady who moved here from Boston who managed a restorative justice diversion program in Boston, and as she told me about it, I became convinced that is something we will look at here in Thurston County. And she has a very specific model for how that has worked, and it's been very successful. So I'm incredibly interested in that idea.
Okay, thank you very much. We're going to now go to closing statements. And Victor, would you like to? Okay,
Well, first of all, I just want to say that I really, really appreciate everybody being here, and I really, really appreciate Senior Services for hosting this forum. This is an incredibly valuable opportunity for, frankly, both you and for us to be able to dialogue with you about what our perspectives are on criminal justice. I've worked very, very hard over the last 30 years to be a trusted and experienced champion for community safety and for justice. I already told you what my four pillars are in terms of community safety, supporting victims, being smart on crime, and being an advocate for prevention. And that will carry me through into the next term. We have accomplished much. We are seeing the results. The data is coming in as being successful, but there is work to be done. The next term for me focuses on reentry and bail reform, which I already talked a little bit about. But the place where we have really fallen down, I think, as a state, is not providing good, supportive, coordinated reentry services for folks coming out of jail or prison. In fact, most people coming out of jail or prison on a property offense now are not even supervised by the Department of Corrections. There's basically no services there at all. I think there's a way that we can just take that on at the county level without increasing costs, because we have so many rich organizations in this county who are ready and anxious to help with this task. I am a collaborator and I'm a coalition builder by nature. I've been doing it my entire career, and that's how I plan to continue to move forward and address that issue. We can do it without making it more expensive, but actually in the long run I think we can make it cheaper because we can reduce recidivism and contain those costs. Thank you again for allowing me to be here and to share my ideas with you.
Thank you. Before I start my closing, I just have to say that when I was an Assistant Attorney General in the Torts Division in the Department, I represented the Department of Corrections, and one of the major types of lawsuits it would get was from victims who had been harmed by someone who had been improperly supervised by the Department of Corrections. So to hear that the county can suddenly take that on without increasing its liability surprises me. That would take some kind of legislation, immunity, a lot. So that was surprising to me. But going on to my concluding statement, I'm sorry. Again, I have 15 years experience as a high-level prosecutor. We're not talking about goals so much as effectiveness. And the effectiveness isn't shown in the numbers here. We're talking about someone who's basically had 15 years to turn things around since 2003, and with full authority since 2010. And good intentions are not that he hasn't done the job, and a change is needed. We are spending more money this year in our county budget than we're taking in, and that can't go on. The things I'm talking about doing, we should have done years ago. How many more hundreds of thousands of dollars a year are we going to waste to give time for someone who's been proven not to be able to do the job, frankly, to go forward? We need change, and we need it badly. We need change at all levels of the government, and we need to do it soon. We need to try new things. We need to try effective things. We need to have standard rules and procedures that can be followed by all prosecutors and have everybody on the same wavelength in order to save our county, because we're headed towards insolvency, and I want to stop that. I would love to have your vote. I can't do it without your support. Thank you.
Ladies and gentlemen, these are your candidates for prosecuting attorney in Thurston County. Let's give them a big round. Over to Eileen Mackenzie Sullivan for a little housekeeping issues.
Thank you so much, Claire. Let's give our wonderful moderator, Claire Ferris.